You go. Okay, well, welcome to our June presentation of the Fiduciary Education Forum. I welcome all of you for being part of this. My name is Todd Wohl. I am with Braun International and Premier Estates, International Real Estate. We are the hosts and the founders of the Fiduciary Education Forum. Um, Group, as we like to call it. It's purely focused on education for professionals in the trust and estate and litigation and real estate world and so on. Um, Fiduciary Education Forum, we started about 3.5 years ago, and all of our videos and presentations are up on our website, which is fiduciaryforum.com. That's fiduciaryforum.com if you want to see previous presentations and uh, the video version and also the printed version when they were available. So welcome everybody. I'm really fortunate and honored to have two esteemed panelists. First, LauriAnn Wright of WKD Legal in Los Angeles, and David Berrent from Pais Montgomery Fiduciary. LauriAnn, if you would, please introduce yourself.
Sure. So I'm LauriAnn Wright. I've been practicing law over 30 years. My firm is 8 attorneys in Glendale, Wright, Kim, Douglas, and we pretty much 80% of our caseload is representing professional fiduciaries, usually in complex and contested matters, where we help them sail through the waters, hopefully unscathed of family fighting.
And I'm David Berrent from Pais Montgomery Fiduciary. We are a fiduciary firm with 5 fiduciaries and support staff. I sort of specialize in complex financial matters and business matters. LauriAnn was my very first attorney on my very first case, and we've done a lot of case work together. And she's become a good friend and a great partner to help support me and watch my back.
Well, thank you both. For everybody who's going to be on this, we'll leave the chat room open. We'll try to answer the questions if we can during the presentation. This is a pretty a complicated presentation. Um, so for you advanced specialists, I think it'll cover a lot of topics. As you can see, it's about selling squabbles, how to sell minority interests and majority control in real estate and business entities. Um, so we will get going. And I guess, David, if you want to just uh,
Sure. This
box
was
this in for everybody.
this was a pretty complicated matter with lots of parts to it, but the biggest part of this case was a pre-death trust contest over the ownership of a chain of franchise food restaurants. The My client lacked capacity, and he owned 51% of these chain of 20 fast food restaurants, and there was a pre-death trust contest of who was going to own that 51% upon his death. It was either going to be his new wife or is going to be his children. So there was a new trust giving his 51% to his new wife, and the children were contesting it. And that's the root of the story. It gets more complicated as we go on, but that's the basic genesis of this case.
Okay. Lorianne, you want to add anything here?
Something I would add, just technically speaking for the lawyers, is we call a pre-death contest a petition for substituted judgment that's brought in a conservatorship. So our hypo presupposes we have a conservatorship and the majority owner and the franchisee is a conservatee. And in our particular case, he had a degenerative disease. And we're going to be we're going to try really hard not mention the actual franchise that was involved. So we're going to use Krusty Burger from one of our favorite Simpsons characters, right?
Yeah.
Everybody likes a crusty burger. Okay. Marshaling the company bank accounts, gaining control of the business overall. David, you want to start here?
Sure. As all producers, we know marshaling accounts for clients it's very difficult and time consuming on personal cases for either conservatees or trust account. Taking over business accounts is way harder, especially if there is another owner on the account. In our particular case, we had a minority owner who was the ex-wife of my client. She had a minority interest in this account. She was uh, very difficult. She had many issues, and she had access to company. We all know that as fiduciaries, you want to be the only one touching the account, touching the money. Well, she would randomly take money whenever she wanted, which was causing conflict in the bank accounts to make payroll and other things. But getting on the bank accounts is really, really problematic. What they would allow me to, even though I even had a court order to do so, they wouldn't let me on. They would what they would allow me to do if I wanted to. I could close all the bank accounts and open new ones, and I'd be in total control. But now, the pragmatically, that's impossible. There's 20 stores. There was over 35 bank accounts and over 80 credit card merchant accounts, and trying to get all those to work overnight to switch from one to the other would cause irreparable damage to the company and harm. So it was very, very difficult. And just know if you take over a business bank account, getting on the accounts is difficult because you need to control the cash.
And the wrinkle we had, you guys all know, I'm sure you're all experienced in the world of small business, these owner operated businesses, they tend to just take cash whenever they need it, right? They don't understand the rules of uh, you really shouldn't be commingling. And so we had to deal with this issue, and we'll probably talk about it later, but they would just take money whenever, but they were S corporations. So you're supposed to, right, take your distributions in your pro rata ownership share. So our conservatee should have gotten 51% and 49% the ex-wife. And they were all over the place, and we'll get to it, but the books were in shambles. So we do have this, there's a legal issue and a tax issue overlay on getting control of the cash, because sometimes you might have to cut them off on distributions until we can catch up and get them in the pro rata shares so they can keep their S corp status. Losing S corp status would have been a disaster, because then they'd have to file amended returns as C corps and incur additional corporate tax, which just is not.
So I think one thing
not
I want to add here for our viewers, of course, there's a real mix of parties involved here that are viewing this. If you don't have the financial acumen within your company or yourself, you want to bring in, controller, bookkeeper, accountancy firms, especially when you're managing lots of money in different entities, right, David? You've
Yeah,
got to control, and you have to. I think one thing I hear constantly as well, are we going to be able to bill our client for this? Are they going to pay for this? Right? So you have to take a firm stance that the services that are required to keep the business operating or right the ship, as I like to call it, they have to be paid for. You can't try to do it off the back of a napkin and do it yourself. If anything, might put yourself in peril.
yeah. I
Uh,
will tell you, in our particular case, they had no company financials. The company financials and the tax returns that were filed never met. They had no relationship whatsoever. We had to manually recreate financials going back a number of
yeah.
years, which
David,
was costly.
tell everyone where the bookkeeper was located.
The bookkeepers were located in Argentina, and so it created a pretty difficult working situation. And we had
Those
to
Okay.
balance sheets didn't balance. That's your
balance sheets
first
didn't
note.
balance. Uh,
Something was wrong.
So let's go on to understanding your official business role, that David, that you had in this case. Why don't you start
yeah.
with this, if you
So
like?
the first thing is you need to examine the corporate documents, understand what kind of corporation you are, and what powers you have in your role. In my role, in this particular case, I was the controlling partner of 5 S corporations, right? And those are, and there's documents relating to what role I have. So you need to review those corporate documents with your attorney and make sure you fully understand your role. Now I've taken over family businesses and I have taken on official corporate roles like CEO and CFO. I would say avoid that at all costs if you can, because as you know, as fiduciaries, we're paid for not our billable hours, but for the bullseye we wear on our chest. When you take on those official corporate roles, that bullseye gets a little bigger. But there may be instances where you really have no choice. If you do, just make sure you get D&O insurance and get the biggest policy you can get to protect yourself.
Like in
Uh,
our case, we're going to talk about it more, but the ultimate fight. And for those of you who are just joining us a little late, the context of this is we had a conservatee who was a franchisee who was losing capacity. There was a conservatorship, and he had 3 groups of women basically fighting over his money and his franchise assets. There was the ex-wife, who was the minority owner. There were the daughters from the first marriage who were not only fighting to get control, but fighting their own mother. And then there was the new wife who just wanted them liquidated. She just wanted the cash, as well, perhaps new wives do. Anyway, so we have this context of 3 groups of women surrounding our conservatee who are all pulling things one way or another. And just to put the probate angle on it, David was able to run the businesses because the probate code has this really interesting statute, probate code 2590, 2591A, that grants conservators the power to run a conservatee's business. And that's literally pretty much all the statute says. It's really amorphous, which is kind of good because it just meant that David was able to step into our conservatee's shoes informally in all of those corporate roles without having to formally take them on. And our judge was really smart. He gave us this limiting language to those independent powers that in retrospect, we were so glad we got. And what he specifically limited to was he said David was to exercise his independent powers in the most narrowly fashioned method as possible, as determined in the discretion of the temporary conservator. And where that turned into a great thing is, as you can imagine, anytime something didn't go well, the minority owner tried to make it David's problem. And then anytime David needed to intercede, she would complain that that was not within his powers. So at least this limiting language of exercising powers in a narrowly fashioned way meant we could step out and say, we're not covering that issue, minority owner. That's day-to-day operations. It's not what this conservator is doing, right? We're just stepping into the owner's shoes to run the businesses. Ultimately, by the way, we were looking at David coming in as a director and officer, but only for a day because we'll be talking about this later. A fight ensued about whether to sell these interests to a third party or to sell them to the minority owner, the ex-wife, who wanted a big discount. And in the overlay is the franchisee. So in our hypo, Krusty's Burger corporate was really breathing down our neck about doing a transition of some kind and quickly because they didn't want, Krusty's Burgers is a fine establishment and they wanted to make sure it was being run in accordance to their franchise rules and keep up their brand identity. And they didn't like this just hanging out there. I mean, David, are you an expert on Krusty's Burgers?
No, this brings up an important topic. I've taken over family businesses, manufacturing business, fashion business, chain. You are responsible for the day to day, but you don't have to run the day to day. In all those instances where I've run a family business, I hired a specific person who had experience running franchises. I had hired someone else to run the day-to-day operations of this apparel company, another one for a manufacturing business. So, but you're still the ultimately responsible for making decisions. So, but you need to get someone in place to run the day-to-day operations.
That's right. Find the specialists. Before we move on to the next page, there is one thing that is very important for all of you, if you're paying attention. It says, are you a majority or minority owner? How are you going to determine that? Well, the operating agreement that is essentially, I like to say, your Ten Commandments, your Bible, everything in that operating agreement for the entity has to be followed because that is how it is. That's how the partnership or entity is written. Therefore, what's very important, and we'll talk about it in a few more slides later. But knowing that you have the correct operating agreement and have there been any amendments to it? Has it been updated over the years? Because some partnerships may be decades old and people don't even remember what they say. Or have they been updated? And you've got to make sure you have the most current language to follow because if you do not, you may be, you may be uh, ill-advised, candidly. So something to keep in mind. Let's talk about preparing for a sale. David, if you just want to run through this quickly, what did you have to do?
Well,
Uh,
in this particular case, there was no financials whatsoever. So they didn't exist. So we had to create them and refile the taxes. So you're not only you need to have create have financials, but I had an accounting firm create financials, and then we send them to another accounting firm to be reviewed. So they're ultra clean, right? So you not only need to create financials and then reviewed financials. So
Especially
it's
because we were selling, right? So we
right.
thought we might be dealing with the lender and they're going to require reviewed financials.
Yeah, and you need to make sure all your taxes are current, right? So you need to do a full review of your financials and your taxes, make sure they all align. They need to be reviewed. I just want to add one further note on our previous slide. If you're a fiduciary and you are going to take control of another company, before you decide to take on that matter, think about the work you do for your clients. And then think about just the work you do to running your own practice, right? This this was a very consuming case for me. It required you're running a company. And even though I had someone running the day to day, it did suck up a large part of my day every day. So if you're going to take on a company that's running a company, be prepared to be busy a lot.
Well, I think, sorry, but one thing I think we want to keep hammering is because I see this all the time with fiduciaries that we work with, they don't want to or know who to hire to help them. The CPA, the accounting firm, the bookkeeper, right? As David said, a specialist operating the company. I mean, it's very important to have these key people as, as your, I guess to use the word partner, right? Because they're helping you on the day to day. You can't be involved running 22 Krusty's burgers that you have no experience doing.
But there was
So,
never a day, there was never a day that I didn't get a call and David had to make a decision or get involved in some fashion.
right.
It was
Yes.
also never a day that David didn't call me to help
Yes, exactly.
There you
navigate that
go.
decision.
So,
Um,
going into go ahead, David, real quick.
yeah, the real estate. So here's yeah, this is particular. This is for all businesses, but in particular for franchises. Let me explain something to you. So a franchise, owning a franchise is a contract. I can have this franchise for a term, for a period of time, 10 years, 12 years. You must, as a part of your franchise agreement, you must have a lease for the real estate that accompanies that business for the exact same term, right? And that lease must be transferable to a new buyer if it needs to be transferred. So that's part of your requirement in a franchise, and it's in any business. Where is the business being held? But so why is that so important? One, it's a breach of the franchise agreement to not have a lease. But here's why it's really important. If you want to sell your franchise, they both need to be transferred at the same time, even if that owner owns both the franchise and the building, right? But if you don't have a lease, then you can't sell the franchise. So what you have is an unmarketable asset because you need both together. You sell the franchise agreement and the lease goes to the new buyer. If you don't have the lease, your franchise, which was worth $2 million, is now worth zero. And in our particular case, we had 20 Taco Bells and 10 of them did not have leases. So that had to be corrected. So,
So,
And by the way, I went into court to get court approval because those 10 leases, our gentleman, our conservatee, had been very generous to his family, had set up idiots. I don't know how many people here are trusted estate lawyers, but those are intentionally defective grantor trusts that are used for gifting for family and hopefully discounted minority interest. So you can get that discounting and move some money, assets out of your estate and limit your estate tax liability when you pass. So he had set that up and already gifted out. Ooh, I think 8 out of the 10 he'd gift. Oh, actually, 9 out of the 10. He only kept one piece of property for himself. So we had that wrinkle. And since we had 3 groups of women all hovering and fighting each other, I went to court to get all those leases approved. And the one that didn't get approved, surprise, surprise, was the one property the new wife owned because ultimately the ex-wife bought the franchises. Can you imagine? He set this up where new wife had to negotiate with ex-wife on a lease. How do you think that went?
not well. One thing I want to talk about when you talk about leases, for all of you, if you never get involved with a franchise, even if you have an apartment building or a retail center as a tenant or an industrial building and you have a tenant, if you're going to keep the building, sell your interest in the partnership, those leases are crucial in helping you determine what the value, or us as your broker or appraiser, to determine what the value of that property is. So again, going back to knowing where the leases are and have there been any extensions or options that have been granted over the period of the term of the original lease. You've got to make sure you've got your leases in check. And if you don't have them, where do you find them? Well, the easiest, of course, if nobody's there to help you, is go back to the tenant. They will be the first to generally help you get them.
Or the
Um,
landlord? You mean landlord?
well, if you are the landlord, I'm saying if you're a
Oh,
fiduciary, LauriAnn, you own an apartment building and you've got 32 tenants and 32 leases. How do you get those leases if you don't have them? If you don't have a property manager, they may
yeah.
not even have them. You go to the tenant. So that's one quick way of getting into it. The next
what, what,
slide.
one other thing about the leases,
Yes,
you need to, especially for brand, they have options. You need to be aware of
right.
when the option, because we had a situation where lease options were not exercised, and then we were now subject to now renegotiating these new leases. So these lease options weren't exercised. The owner then played that card and upped the rent significantly. So
So for all of you, who can help you do that? Well, it would be LauriAnn, her partner, who's a real estate attorney, can review the leases, consider the issues surrounding that lease, if there is an option, if it has it been executed, or if it's just a tenant in an apartment building. More simple ones. It would be people like us as your broker or whatever to analyze the lease and determine if the leases are in force or not. So if you don't have the real estate background, again, saying the same thing, hire the professionals to help you do what you need to do. Um, this one we'll go through real quick, David. Human resources and
yeah,
employees, if you
so
want to
in this
touch on it.
particular case, they had 400 employees and no HR person. And during my tenure running these franchises, I was involved in 3 class action lawsuits. Owners of businesses in California are sitting ducks for employment lawsuits. I'll just say
Yep.
that. So the other thing you need to do when you take on a business, one of the first things you need to do is hire an employment attorney to review all documentation, do a review of all of, payroll records, timesheets, the employee handbooks. You need to do a comprehensive review of what the status is. I was involved in 3 class action lawsuits. They're ugly and they were expensive. And if you ask me, they did have some very, very minor discrepancies in it, but that for that one little tiny mistake cost $800,000.
And
Okay,
of
good,
course,
good
if
to
you're
see.
headed into selling, and if it's going to be a stock sale, which we're going to describe in the future in a few slides, if the buyer is going to buy the stock, they're keeping the liabilities. So we found that we needed to settle these outstanding employment liabilities. Otherwise, the buyer was going to do the parade of horribles and assume the worst and try to chisel us down on price. So I think it's really important to minimize and settle as much of this employment litigation as you can. And really quick, you may end up firing some people because often they put family members in that are underperforming, right? So we ended up doing that. And our franchisor, Krusty's Burger, did require that we hire a consultant as part of what they called the legatee process. So we were required to hire that consultant, not only it being a great idea, but they wanted to make sure that somebody who knew the brand was helping David in his role. So the stores are being run as they should. So just some
Okay.
other things to think about.
LauriAnn, next slide. When to seek court approval? You talked about the first bullet point.
Mm-hmm.
Let's look at the next three, please. You want to just opine on
Yeah.
those?
So in a probate estate, there's something called IAEA authority. It stands for the Independent Estates Administration Act. And if you have those independent powers, you can sell without going to court for approval. But my question is, should you? I would not. But you could do what's called a NOPA, which is a notice of proposed
Right.
action. In a state, it goes quick. It's only 15 days that you give them to decide if they want to object or not. And if nobody objects, they're deemed to have consented to your action. So this NOPA would attach the purchase and sale, proposed purchase and sale contract, all the details, get them a chance to look at it. Now, if someone objects, then you have to file for court approval, and you should. In a trust, it depends on whether it's court supervised or not. In our case, the trust was put under court supervision, in which case you basically run it like an estate. And even if it's not under court supervision, it's such a big transaction and you have all these competing stakeholders. You probably want to get that court approval anyways. And very often, if you check the orders in the case, judges typically actually require court approval for large sales. Like the court would have known in this case we were looking at selling, right? Like just writing on the wall. You see this in real estate a lot. Like you come in as the fiduciary without court approval on anything except for, you sell the major apartment building, you need to come back to court because the court knows that's a controversial decision. Um, so, one hot tip just while we're here, because David was a fiduciary, he has to provide accountings to the court. Can you imagine creating accountings for 20 fast food restaurants, accounting for every burger sold? You can't. So I got a specialized order from the court that the accounting for the businesses could be financial statements, and that, get that going in so you're not scratching your head at your first accounting going, how are we going to do this?
So, LauriAnn, let
Yeah.
me ask you a question. In the sale of the real property,
Hmm.
have you gone back when you felt a NOPA should be used for whatever reason? Will you go to the parties that would be, well, the Bennies or the whoever that would be the recipient of that NOPA? Do you do that in advance of preparing for sale, or do you do it after you have an offer in hand?
Well, so you would break down the NOPAs in two. The first NOPA would be for listing. I want to list at this
Right.
price. Here's the listing agreement. And yeah, I think for a big transaction, that's smart. And then when you get an offer you want to accept, and your offer needs to say that it has that contingency of court approval if someone objects to the NOPA, right? Then you send out the NOPA. So yeah, breaking it down does make sense. Just
Okay.
less controversy. Or in our case, our gentleman had gifted away everything else of major value. There were some other assets that added up to a few puny millions, but nothing like what he used to have before he gifted. So the franchise entities in this case were worth $40 million. It was a big pot to fight over. And ultimately, it had to get resolved at mediation between those three groups of women. They all had to finally agree who was going to buy and for how much, because everyone wanted to buy them or liquidate them in some form to their advantage.
Right. Okay. Let's go on to trust versus conservatorship ownership. David, anything you want to add on this slide that you first talk about?
Um, it didn't. This necessarily didn't necessarily have a. Well, here's where it became a problem. So this gentleman had placed his ownership of his 51% in a trust that was not approved by the corporate owners, which immediately caused a problem. That is, they need to approve it. Needs to be put in a certain way with certain language. It was irrevocable. Lori, what was the issue?
It was his revocable living trust. And just so you know, there's no franchisor ever who's going to allow you to put these interests in an irrevocable trust, right? They want to be able to see through the trust and see that
Yeah.
their franchisee is the person who's the trustee and in charge. They don't, I mean, they're so protective of their brand as they should because that's all they're selling. They're selling a brand, right? And maybe some
Yep.
of the food and ingredients. So they have to
Yep.
protect that brand. Absolutely. So they
Yep.
need to know whoever's running that business is in charge, knows what they're doing, has been to Krusty Burger School, right? Keeping up that valued brand.
Right. So what
Yep.
happened is these ownership were taken out of the trust, and now they're in conservatorship land.
Oh yeah, we had to. They put us in violation of the franchise
Yeah, that
agreement.
put us in violation. So we had to remove them from. So now our client was in danger of passing. So now we're trying to avoid, an asset worth 45 or $50 million in a probate. So now we're scrambling to get this new trust drafted and approved and get them back in the trust. And at the time, we thought he might pass before we could complete that. So that's where this became an issue. So you got to make sure that if the ownership is in a trust, it's in it that it was that the trust, the language of how it was done, the way it was assigned, the assignment was done correctly and approved by the corporate overlords.
And by the way,
Okay.
lawyer and the fiduciary make more money if it was on the conservatorship side and he had died. But then the beneficiaries would have blamed us for not getting it in the trust and saving on the cost of administration, right? There's statutory fees, and they would have been very large for an asset of this
Mhm.
size. And they would have blamed us, and it would have been another piece of litigation. So we did what was right and got it in the trust, which is definitely what our gentleman's estate planning intent was.
Okay. Thank you. Thank you. Let's move on. Valuation and appraisals of business and minority interests. Well, I guess, LauriAnn, why don't you, as an estate planning and litigator, talk about the importance of these factors, and then I'll chime in. Go ahead.
I'll tell you the first thing we think about is who are we going to use because of the cost, right? And so that overlays with, well, what's the purpose? Because you can do a broker opinion of value, a BOV, and it will be cheaper. But if we need it for tax purposes, well, the cheaper, you need a licensed appraiser to defend an audit, right? So we're
Yep.
dealing with that. And obviously, if there's a liquidation event coming, meaning we're selling, you need a good appraisal. You need to deliver to those beneficiaries and the stakeholders. This is how much this is really worth. And, it's David's job as the fiduciary to stand up for our conservatee. This is his life's work, this asset, and to make sure that he's getting good value for it, despite the context of the family fighting. So you don't know what that is until you've gotten an appraisal,
Right.
right? So it's
Right.
very, very important. And to get it early to start those settlement discussions is important.
So for those of you who know us, we are real estate appraisers and business asset appraisers, separate from our sale platforms and groups. Engaging an appraiser for real property. The one thing I can advise all of you, make sure when you hire an appraiser, he or she understand the purpose and scope of what it is they're going to do. Who's going to see the appraisal? How are you going to use it? And what is the deadlines that you're going to tie that appraisal to a sale for? Pay attention. An appraiser, whether it's a business or real property, it is their decision. It is their opinion to determine how long that they state in the appraisal that value is good for, meaning how long will it take? Do they believe in the market to obtain that price? We all know that not one property, if it's appraised for $2 million, hypothetically, it's going to sit on the market for sale at $2 million for a year. We all know that's never going to happen. So it's very important to discuss with the appraiser the purpose and scope so the appraiser understands that, okay, this is for date of death purposes, there'll be no sale. It's for gifting, for 709 purposes. That's for gifting. It's not for death. What are you achieving? What are you trying to do? Educate the appraiser so they can provide you with the most accurate value for purpose. On the
One other
same,
thing,
yes, go ahead, David.
one other thing to keep in mind, in order to do that, we have to go back 3 or 4 slides about the company financials, right?
Yes.
They can't do it unless the company financials are accurate and reviewed. So that's before you can get to the appraiser, you need to get that part done because they
So
need the real numbers to work from.
we have a client right now where we're valuing 32 partnership interests that own a total of 50 properties in 4 states, and they do not have the financials all together. And we told them, here's the list of things that we need to do the valuation of the real estate and for the entity, for the discounts. It'll probably take them 3 months to get it together because they have no idea what they needed and they have no idea how to get it. So we're trying to help them do it, but they have a deadline and they thought the appraiser could just wave his magic wand and okay, here's a value. Well, garbage in is garbage out. So getting the appropriate data is the key point for a valuation. The third bullet point on this page, because I don't want to take too much time up on this, how to value minority interest, time to market value of the sale and share minority interest. For those of you who don't know this, yes, we have a platform, LauriAnn knows this, called Mimics, Minority Interest Market Exchange. We are the experts in selling partnership interests. Well, I can tell you, again, the valuation of the partnership interest always ties to the underlying business. So to get to the value of that 12% interest, you have to value the business or the real estate, or some cases both. So it can be it can take a lot of time. And as David said, it can cost a lot of money, but it gives you a guidepost if you're going to sell. But a good appraisal firm will ask you and guide you and tell you what you need, what you need to do, and so on. The BOV versus licensed appraiser, well, I can tell you as a broker to sell a house, we're asked for BOVs probably 30 a week. Is that better than an appraised value? Well, the BOV is, let's call it current. The appraised value may be historic. If they're both tied to the same, the appraiser will come up with a highly different value than us as a broker, even though we're both. Why? Because a BOV can take into account active inventory versus an appraiser who cannot. But a BOV cannot be used for any kind of IRS filing. It has to be an appraisal. You're guaranteed. We don't even do BOVs for date of death or gifting valuations. It's not even worth the risk. And does a BOV withstand IRS scrutiny? No, because the IRS will say, "What is this? That has no value." Um, Anything else? I think I'm good on this page. LauriAnn, let's go to this one, an important one. We got a limited time here. Right of first offer versus right of first refusal. You want to start here?
Sure. So the ROFO versus the ROFR. And this is where you go back, like Todd said a few slides ago, the operating agreement is everything. So
Yep.
you got to go look, is one or both of these offered to the other shareholder that you're trying to sell their interest or have them buy your interest, right? So a ROFO is a chance to buy before it's even listed and marketed to third parties. And there's usually in the operating agreement a process. It's the appraiser full employment bill. The
Yep.
buyer goes and gets an appraiser. Then if the seller doesn't like that, they go get their appraiser. If they still don't like that, then the two appraisers pick a third appraiser. And then the three are like averaged. That's, I think, the typical term. And then they buy
Yes.
it at the appraised value before there's any exposure to the market. And I find business owners, they just do these operating agreements and they don't realize
Yep.
how important these terms are. They don't even realize they're in there. Now, the ROFR is post-listing. It's a right of first refusal. So a little negotiating tip here, or a strategy tip, is please do not list these to third parties as stock sales, because you'll get lowball offers, and that other owner will be so happy to exercise their ROFR and abandon their ROFO process to sweep in with their ROFR and match that lowballed third party offer that came in on a stock sale. So, if you're going to list as an asset sale, and that's the next slide, we're going to explain the difference, but there's a big difference in price because
Yes.
liability
So
or no
what
liability.
one thing I want to I know we got limited time, but one thing I want to add on a right of first refusal is very important for all of you to know. Let's just say you have a very simple 12% interest in an entity that owns an apartment building that your client owns. Very common for fiduciaries. We deal with them day in and day out. A right of first refusal does not mean that the general partner or the person or entity that has that right, it does not mean that the asset, the interest, whatever it is that you own, cannot go to market. There's a distinct difference here. You can go to market. You just have to take that highest offer that has been achieved in the open marketplace and go back to the party who has a right of first refusal and say, okay, we got an offer for $3 million. Do you want to match it? And they say yes or no. And they'll have generally a timeline to match it, 30, 40 days, whatever's in the operating agreement. And if they buy it, great. If they don't, then you sell it to the party who offered $3 million. So a right of first refusal does not mean you cannot go to the open market. As a matter of fact, I hear it from attorneys all the time, not smart ones like LauriAnn, but a lot of them say, well, you have a right of first refusal, you can't go to market. Well, go to court, see what the court says. The court's going to want to see you take it to market so you can then show you ran a commercially reasonable sale and you obtained a commercially reasonable offer. It could be the same if you're selling a 50% interest in a house that the brother and sister own. Same thing. Just be advised of that. It's very, very important to know. I hear this all the time. It's amazing. People don't understand ROFRs. Stock sale versus asset sale. LauriAnn, come, let's go through
Oh,
this
I
quickly.
noticed a question, Sue, and maybe we missed her a few minutes ago. I think it's BOV. She said, what's a BOD? I think we talked about BOV,
BOV,
broker
broker's
opinion
opinion
of,
of value.
yeah. Oh, by
Sorry.
the way, Todd, really quick, because I hear this all the time. Do you think the existence of a ROFR depresses offers from third-party buyers? Because, oh, well, maybe I won't end up with it. That other owner is going to swoop in. Like, why do I even want to bother submitting an offer?
So, LauriAnn, that's a very good point. I would say to you, 50% of the time, the assumption is that there would be some push down in value because of a ROFR. The reality is, once you explain it to the buyers understand. So, as a broker, if I have a ROFR overshadowing us in selling that apartment building or that house, right? All we're going to say is to the buyer is if you don't put the offer in, you don't get the opportunity to buy it. So even though there's a ROFR, what is that saying? Somebody may or may not buy it. It's no different than a probate court where you have to go into court for overbidding. Well, I shouldn't put an offer in because somebody could overbid me in court. Well, okay, then you're basically shooting yourself in the foot by not taking advantage of the opportunity to submit the offer. So it's a talking point, but we get through it. So it does take a little bit of an education, but that's a good point. Asset sale
So,
versus stock sale. LauriAnn, you want to go through the risks of stock sale, or David add something to this?
Well, when you're selling us the stock sale, what you're selling is the shares of the company that the owner to the next buyer. And when when they're buying buying the stock, they're also buying all the liabilities that go with it, which is why it's cheaper. So why you're going to get lower bids for a stock sale in general, right? When you're selling an asset sale, what are you selling? I'm selling. I'm not selling the actual corporations. I'm selling the franchise agreement and the leases and the equipment and the actual assets that are on the balance sheet. That's what I'm selling. The stock sale is everything that goes behind it. all the tax liabilities, all the other nonsense, which is why, at least in if for franchise sale, it is almost always an asset sale because
To
nobody
third parties, to third
to
parties.
third parties.
Yeah.
If it's an internal sale to an internal party, then you're selling the stock.
And just so for those of you, you know, there are certain types of sale procedures, assignment for the benefit of the creditors, that actually, or an Article 9 sale that would circumvent the stock sale process and go to an asset sale. An ABC, an assignment for the benefit of the creditors, is more of a bankruptcy related procedure, but it does cure this issue of stock sale. But you know, I think for most of you, you'll probably rarely see this. You may be that partner, that limited partner in an entity that owns a shopping center, an apartment building. There, candidly, you have no choice. You have to sell your 12% interest. You can't, it is not an asset sale. Well,
Can
we
you go back?
spoke
Can you
about,
go back? It's one of the things I want you to skip
yeah,
to
go
one.
ahead, David. Go
Go
ahead.
back one.
There
So
you go.
on the asset sale, maintaining there, you need to maintain a very healthy reserve for any because if you're selling the assets, right, you still own all the liabilities, right?
Yep.
So you need to make sure that from the asset sale, you maintain a very healthy reserve to pay any of those liabilities.
And remember, like if you have a situation we had with a owner operator who built these himself over decades, he clearly, they were not corporate positions filled that you should have seen. Like we mentioned, there was no HR. He was doing everything, but when he lost capacity, things were slipping, right? So there's going to be more liabilities. There were major tax issues we haven't even touched on, like payroll tax issues that have a personal liability component. So if you have a distress sale, as I guess we could call our case, there are going to be more liabilities. So we ended up selling as a stock sale was wonderful because our guy got his money clean, no liabilities. They stayed with his ex-wife. She gets to deal with them.
Yeah, that's a good point. Okay. Sale without confirmation, we kind of talked about this a little bit. I guess I'll start with this. On the selection of a broker, I mean, you know, we're talking about our Mimics platform, but that's for minority shares. If you're talking about the sale of, you know, of an operating business like David was involved with, you are going to bring in a specialist. You might bring in a investment banker firm or a brokerage firm, or business brokers that specialize in the sale of restaurants. Obviously, industry specific types of brokers exist, and it is good to, you know, understand who would be the best or what company would be the best type of advisor for you in the sale. Um, you know, I mean, again, this is kind of just ancillary information. The marketing process. Having a non-disclosure agreement is critical. We never sell a partnership interest or an interest in an entity without an NDA and a confidentiality agreement. We give buyers the access to the data room once that's received, and that in some cases we will pass on the confidentiality agreement and the NDA to the lawyer representing the state for their approval and you know, look up who that party is signing the NDA. So there aren't insiders that are trying to, candidly, we've seen it happen a lot. You know, muck up the situation. Um, and then the offering memorandum or CIM, as it's stated here, will provide all that information regarding the business and the entity. So that's all part of the marketing process that we or, you know, a professional would do. LauriAnn, a sale without confirmation, the transaction process. You want to talk about this quickly?
I'll just say really quickly, the part that concerned us is, we're in the context of litigation. We have these three camps of women ready to blame us for any move that they feel wasn't in their best interest, right? And we're trying to avoid incurring costs before we need to. But the Krusty Burger was giving us really strict deadlines. Like, you need to resolve this by this date or we're pulling the franchises. So we're going to go from 40 million to zero overnight with these deadlines. Meanwhile, they all needed to settle and they weren't. So what do we do? So we got court approval to hire an investment banker, which is the fancy term for the brokers for these larger business sales. And as soon as we signed that contract, that listing agreement, or they're called, oh, what are they called? I forget what they're called, the technical name for those agreements. They're not really listing agreements. They have a fancier name. The success fee is about 2%, which is their commission. It's pretty big. And as soon as we signed, that would apply to a sale to the minority owner or to a
Right.
sale to a third party. That money would have been bye-bye. And that was pressure we were able to use to get the parties to settle ultimately. But ultimately, our investment banker, I think, was just tired of hanging around and eventually agreed to a flat, like kind of down payment fee that he would
Right.
get no matter what, but agreed to exempt the minority shares from the success fee. So we were able to list and we got some letters of intent, LOIs from some potential buyers. And that's how we knew these things, despite the appraisal being less in the market, were really worth about $40 million.
Can
So
I,
one thing I
Lori,
want
can
to
I, can I, can I wanted to
go
show
ahead,
you
Dave.
one thing that I think is important that LauriAnn skipped over pretty quickly.
Mm-hmm.
So we all know in our world that when you have to, if you want to do something, you petition to court, people object, it's set for hearing a few months later, and that's the process, and it can take forever. Well, in this situation with our franchise holder, with the franchise company, they don't care about the court calendar. There's an agreement that says when he was pronounced lack capacity, that triggered a date certain when transactions must take place. They do not care about the court calendar and objections to this or that. These things are going to happen on these dates, whether you like it or not. And in some ways, it's hurtful. It could hurt you, but in our case, I think it helped us because it did get people to the table and make them get to a settlement faster. But so they don't care. They don't care about the court calendar. If
I
we
think what they did care about, though, is that the minority owner was a minority woman who had been around for decades as the minority owner with her husband and then ex-husband. And I think they were afraid of some sort of lawsuit by her if they didn't give her a fair shot and some time
they
to
did give
buy.
us an extension, but we did two extensions. But the second extension was for sure a hard deadline, right? So it could hurt you, but I think in the end of the day, it helped us by having those hard deadlines imposed on us, right?
Yeah.
Okay.
Yeah.
So, in deference of time, one thing I want to add here, we'll move to the next slide. I would highly suggest never using a letter of intent, what's called an LOI. If you can, have a contract that's either been preformed that the buyers are going to use, or let the buyer put it on a contract. So when we sell, we're selling for a client right now for a fiduciary, a couple of apartment buildings and industrial buildings, and these buyers are putting them on LOIs. And we said, no way, no how. You'll spend more money with attorneys trying to create a contract and go through the LOI. We just put it on a standard purchase contract format for, in this case, the California Realtors Association, or for the properties in Nevada and Phoenix, Arizona, we put them on an AIR contract. But you want to use a contract, never bother with an LOI. It's too difficult, too much time, too much money that you would have to spend.
Of course, we did
Um,
them. We used LOIs, and it took us 3 weeks on an expedited push for we had mergers and acquisition M&A lawyers on our side, and so did the ex-wife, and they were pushing to get this thing written in 3 weeks. I think it depends on the complexity of your deal.
Yes, LauriAnn, you're right. I don't disagree with you about your case, but I'm kind of using the average fiduciary estate and the assets that they get. You try to dumb it down and simplify it so it moves along quickly and your costs are little. Representations, warranties, and disclosures. LauriAnn, you want to just start real quick here so we can get through the rest of the slides. Anything you want to add?
Yeah. So there's no as is sales, which was, I'm so used to real estate sales and probate cases.
Right.
No such thing in a business sale, especially when there's financing involved. Just no such thing. So there is, oh boy, there's something called the data room that David will tell you
Right.
something about that. It is a massive enterprise to do the disclosures, but you want to disclose as much as possible.
So let me explain what a data room. A data room is where you load in the tax returns, the financials, any lawsuits, anything that they could look at. And what you want to create and invite people, and you want to be able to track who accesses it and when, because you want to be able to prove who looked at stuff or who didn't look at stuff. So we created a data room that was filled with a ton of documents that anyone could say that no one could say we didn't disclose this, right? And you want to be able to say, here's when the invite went out, and here's who accessed it for how long and when, and what did they download. You want to create that. They're not hard to create. Your accounting firm could help create that for you. They're not hard to create, but you want to be able to have your data room filled with anything anyone could say, disclosure of anything. Oh, there was something, a dispute with the neighbor, with anything that could cause a conflict down the road. Just put it in there. And then you can keep track of who you invited, when the invite was sent, and who accessed it and when.
When we sell commercial real estate, we use a data room for all those reasons. We put it together, we run it. It is the fiduciaries and the attorneys' responsibility to give us the appropriate documents. But when you talk about disclosures in a business, yes, as LauriAnn said, they're very different than if you're just selling real estate or a partnership interest in real estate. So whoever you engage will help you work through that process. Um, the only thing I say about disclosures when it comes to real estate is make sure you look at your texts and your emails that you received that you had since you've been brought on as the fiduciary, as the trustee, whatever your role is, and make sure you look at those texts and emails from the beneficiaries, from the ex-wife, the person who lived in the property, who run the shopping center or the apartment building, because those disclosures you may forget about. You may have heard something 6 or 8 months ago and forgot all about it, didn't put it in your file. But it is a disclosure. And if, God forbid, you get sued on the sale, they're going to subpoena your texts. They're going to subpoena your emails and records. So you want to make sure that you go back in history and you write a book. That's what I like to say. Write a book. You give it to the buyers. Thank you very much. Here's what you know. Disclosure is key. Just because you have an exempt seller disclosure form that your broker like us would give you, that does not mean it's your get out of jail free card. That's a common question we get from fiduciaries, and I see so many mistakes about it. Anyway, let's see.
Cover just one thing on the
Go ahead,
slide
LauriAnn.
on slide 14. I just want to cover this Jones v. H.
You don't have a lot of time. We haven't got any other
I'm going to
pages.
do it in 1 minute.
Okay, hurry, go ahead.
So David's a fiduciary for our conservatee who's the seller, right? So he's got duties to maximize the price. We got demand letters from the minority owner, the ex-wife, saying, no, 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 David, you have duties to the ex-wife as the minority owner, and it's under this case.
Yeah.
That the majority or controlling shareholders can't do they owe fiduciary duties, let me say this right, to the minority shareholders. And what they were worried about is that David was going to force an asset sale of 100% of the assets and basically force her to sell her shares when she wanted to buy out us so she could own 100%, and she wanted to buy us out at a discount.
A big discount.
Just know that there's that tension of fiduciary duties, and there could be demand letters exchanged and litigation threatened, and you do have to kind of balance these duties. But her being bought out on an asset sale, I don't think was look, she's going to get plenty of money if it had gone that way. And I don't think a court would have found that that was a breach of fiduciary duty, but she might have tried to litigate it. So just watch those competing fiduciary duties and potential litigation.
Okay, thank you, LauriAnn. On this page, tax implications. One thing I want to hone in on is the one on the last section, which is Board of Equalization, sales tax, use tax. I can tell you when you talk about equipment, inventory, personal property in the involvement in a business, inventory, equipment, right? Personal property, that gets taxed on a state tax basis. It is separate than if you were to just sell the real property, right? It's a completely different tax basis. And I've seen a lot of problems where the Board of Equalization finds out about a sale of a company or a sale of assets, and there was not sales tax collected. So, and how do you base that value if you're selling a company and within that you have $500,000 of fixtures, furnishings, and equipment or inventory, right? Widgets sitting in a building. You have to have a separate appraisal or inventory of those assets as a breakout sale. So it's called a purchase price allocation analysis for the sale. I mean, I know this is a little bit more complicated here, but the Board of Equalization wants their money. And I promise you, after you sold it, they come back after you and they say, well, wait a second, you didn't collect sales tax. The penalties are brutal. It's like on IRS
And on
level.
a stock sale, would it? Because you're only selling the stock.
Correct. You're selling the stock in the company. That is correct. You are not selling the asset. So if you're selling one, let's call it one Krusty's Burgers, and you sell it for $1 million, and there's no real estate, what's the breakout of the business versus the personal property? You have to break that out. If for those of you who are selling real estate in LA, we just sold a house for about $5 million. And the mansion tax, those of you who are familiar with Los Angeles, the mansion tax requires a penalty of 5% on anything, give or take, on over 5 million. So what we're doing is we are saying the sale price of the home was 4.7 million and the personal property was $300,000. That skirts the mansion tax. We do the appraisal on the personal property. And then you pay a sales tax as the buyer on the personal property. But the seller just saved 5% on the sale of a $5 million home. So
The
go
best thing
ahead,
here, you
David.
know what? I'm going to really make it easy for you guys. This is super, super complicated. Hire tax counsel.
Yes.
That's it. Don't try to write these notes. Just hire tax counsel.
Well, that's one way of doing it too.
uh,
Oh,
there,
Elizabeth had a question. If a receiver is the seller, is it still subject to state sales tax? And I've never looked it up, but I am
Yes.
sure there's no
Yes.
exception.
A receivership does not have a receiver does not have authority to circumvent sales tax. And by the way, neither does a bankruptcy court. Just so you know, in a bankruptcy sale. Um,
there's one detail that I also not related to this, but before I don't want to run out of time on this because I think it's
yes,
really
go ahead.
it came up at the very end of ours. In your sales agreement,
Oh, yeah.
make it super clear what happens to the cash in the bank accounts. That became a point because at the end of the day, they bought the companies, they didn't buy the cash, right? And that should be in your purchase agreement. Who owns the cash? Because at the end of the day, I scooped up all the cash, and they were like, "What do you mean? Where's all the money?" I'm like, "You bought the business. This is the cash belongs to the seller." So and just make sure everyone has a clear understanding of who owns that cash on what date because
That's a good point, David.
it
Yeah.
became
That's
a
called a working capital adjustment.
Yeah, working capital account.
but
Um, I know we're past. I don't know if anybody has any questions. If you want to unmute your mic, that would be the best way to ask the question if you want. David, would you just give everybody your email address if they have any
yeah
questions for
yeah
you,
we
please?
went through we did a speed reading of this
We sure did.
and there's a lot to know and you guys are all welcome to reach out to me at any time. uh
Your email address, please.
I just
I
put it in
put
the
mine,
chat.
there we go, in the chat.
Okay,
uh,
LauriAnn.
Put mine in the chat.
One other thing
Okay.
for you fiduciaries out there, if you're running a business, we all have our fee schedules. Guess what? The category for business administration is more than I charge more per hour for business administration than I do for trust administration. So if you're billing by the hour on your for a court of for your a court supervised trust or a probate, your billable hours can be greater for that.
One thing that would also include a partnership interest. If you were selling a 12% partnership interest in an entity that owns your apartment building, would apply there too, because again, timely, long, complicated sale process. My email address is todd, at baronco.com. For everybody who's still listening, this presentation And both in print and this video will be on our fiduciaryforum.com website. That's fiduciaryforum.com. There's years of presentations up there. Please feel free to go there. Reach out to LauriAnn and David. We sure appreciate the time for you to be on, especially this long and very valuable presentation. Our next presentation will be right after Labor Day. We're taking August off. So follow us, and we'll get you invited to the next event. And I want to say thank you both to LauriAnn and David for doing this again. We did do this presentation at the Fiduciary Conference in Sacramento last month, and I think we had 150 or 60 people in the room that were listening intently, and thankfully to these two professionals that really know what they're doing. So um, thank you, everybody. We sure appreciate the time. Have a very happy and safe July 4th holiday. LauriAnn, David, anything you want to end with?
No,
Thank you for having us, and thanks for hanging in to the end, everyone. We learned a lot on this one, that's for sure, and hopefully we shared some tidbits that are helpful to you.
bye.
Thank you, everybody. Be well. Happy holidays.